If I got a video for today, see this guy in the yellow on my left. He's he's in cuffs. He's been enjoying state-sponsored breakfast for a while, and he's going to enjoy him for a while later. Judge is going to send him to jail for a bit. Sovereign citizen. Backstory: he came to court on some traffic violation situation. He turned around to walk out of court. Judge wanted to stop him, couldn't find him, and off he went. A month or two later, guy got picked up on the warrant, and so this is where he is now. Sovereign citizen as per usual. Now, be warned, the audio is only on my left ear. I don't know why that is, but it's on my left. It's not bad. You can hear it. I use subtitles because I'm hard of hearing at best. But yeah, this is a very cool video. Let's go ahead and check it out. You will enjoy this one.
I have my rights and I want a lawyer.
I can't.
Please be seated. This is People versus Pablo Forenza, 23T125. Mr. Forenza appears in custody. Mr. McCall is here for the people. Give me 1 second, I'm joining WebEx. I'm trying to. Mr. Forenza refused to stand before the entry.
I can't stand. I'm shackled like a criminal over a traffic citation.
No, it's not a traffic citation that got you in chains over there, my friend. You walked out of court, and they had to pick you up and board you in the local jail, it seems like. That's why you're sitting in shackles. Not a traffic violation. Not at all.
No, you're not here on a traffic citation. You're here on contempt.
Are we having a contempt hearing, Your Honor?
Well, I'm going to give you that opportunity. I'm going to advise you if you'd like it. Let me start by reading the relevant portions of the contempt rule, Mr. Forenza. This is Rule 407. This is of the rules of civil procedure, but that same rule applies to criminal actions such as this one. I'll read the relevant sections. Subsection A1, disorderly or disruptive behavior, a breach of the peace, boisterous conduct, or violent disturbance toward the court, or conduct that unreasonably interrupts the due course of judicial proceedings, behavior that obstructs the administration of justice, disobedience or resistance by any person to or interference with any lawful writ, process, or order of the court, or any other act or omission designated as contempt by the statutes of these rules. This will be direct contempt, and I will cover that in a second, but the rule is contempt that direct contempt is contempt that the court has seen or heard and is so extreme that no warning is necessary, or that has been repeated despite the court's warning to desist. Subsection 4 defines punitive sanctions for contempt, which includes punishment by an unconditional fine, fixed sentence of imprisonment, or both, for a conduct that is found to be offensive to the authority and dignity of the court. Most notably is subsection B, as in boy, which says addresses direct contempt proceedings. When a direct contempt is committed, it may be punished summarily. In such case, an order shall be made on the record in writing reciting the facts constituting that contempt, including a description of the person's conduct, a finding that the conduct was so extreme as that no warning was necessary, or the person's conduct was repeated after the court's warning to desist, and a finding that the conduct is offensive to the authority and dignity of the court. Prior to the imposition of sanctions, the person shall have the right to make a statement in mitigation. Mr. Forenza, I'm going to offer you that opportunity in a little bit.
I don't know, but after what the judge just read there, looks to me like our friend in what's that, Orange? He might be due for a few state-sponsored breakfasts in his immediate future. It sounds like that to me. We'll see what happens here.
I make a specific finding that all conduct that I'm referencing occurred in my presence and therefore is direct contempt. Very specifically, let me make some reference. Mr. Forenza has been disrespectful to the court, to opposing counsel, and even to my clerks throughout the proceeding. He has filed spurious documents. He's made nonsensical arguments. He's been argumentative with the court. But I was willing to let all of that go so we could try the matter. On the day of trial, which I believe is November 24th, Mr. Frenza appeared on time, but stayed in the gallery along with who I believe is his wife. I repeatedly, at least 3 times, but perhaps 4 or 5, told him to approach the court, to cross the bar and sit at table so we could address the trial. Mr. Forenza failed to do so in my direct presence. He told me I had no jurisdiction, left the courtroom, and then amazingly was able to leave the building as well.
I love this this argument that the Sovcits have. You have no jurisdiction over me. Look at where that guy sits there. He's the orange suit. He's cuffed. He's living in the jail right now. Yeah, I don't know. Wild guess. I bet the court has jurisdiction over him, and he's going to find that out. He may live in a dream world. The rest of the world, not so much. There are consequences to what you do, good and bad. Good and bad. There are consequences. He's now got a bit of a bad consequence happening to him. But yeah, panda and breakfast are great. So that's that, right?
In any event, he has not returned since November 24th, other than a few pleadings that I'm guessing were filed that day or the day before. I've had no interaction with this case since November 24th. I make a finding that Mr. Forenza was under an order to perform, that is, to come to the table. He refused to perform in accordance with that order, and even though he had the ability to perform, obviously he was mobile, he was able to make it into the courtroom and then, of course, make it out. He was repeatedly warned, and I note that. I gave him multiple opportunities to approach, and he disregarded all of them. I make a specific finding that I find Mr. Forenza's conduct to be offensive to the authority and dignity of the court. I make a specific finding that he engaged in misbehavior that rises to the level of obstruction of justice. The behavior happened in my presence. The conduct was intentional and willful, and these actions seriously affronted and disrupted the administration of justice. In that regard, I will note that I went and met with the 30 or so jurors who had appeared for the trial, that Mr. Forenza simply blew off. I had to explain why that happened, and I had to waste all of their time. I also wasted the time of the witnesses. Mr. Forenza, I didn't waste anybody. Mr. Forenza also wasted the time not only of the jurors, but of the witnesses, counsel, the court, and everyone else. The court finds him in direct contempt. I made a similar record on the morning of trial, but Mr. Forenza had bolted from the courtroom, and therefore I find he was not advised at that time, so at least not in any significant way, and I hereby advise him. I am considering a jail term for the contempt unrelated to the underlying charges, Mr. Forenza. I'm going to offer you some opportunities of how you want to proceed. First, if you wish, you can make the statement of mitigation right now, if you wish to. If you do not wish to, if you wish to consult with counsel, I will give you time to hire your own counsel, but you will remain in custody during the interim. I would even be open to the appointment of counsel if you believe you are indigent. In fact, I would appoint counsel if you were indigent. How would you like to proceed? Like a few moments to think about that, I'm fine with that.
All right. Yeah. So our genius there. He's not even in court now for the original charge, some traffic infraction. Not even for that. This guy is going to sit in jail for a while for contempt because the court doesn't have jurisdiction over him, he says. Well, look where he is. Looks pretty much to me like there's jurisdiction over this guy. I think so.
Is that the only option is how I like to proceed, or can I make a statement?
Right. So I'm offering you option one and options 2 and 2A. Option 2A and 2B. Option 1 is you can make your statement of mitigation right now, right? And without counsel, the only person in the room other than court staff and the deputy is Mr. McCall. We are live streaming. You can make that. If you'd prefer, you can contact an attorney, and I will set this over for a time where you can make the argument through an attorney.
Yeah, I would go for an attorney. I'm just saying, you know, I would probably go for an attorney. Try to get me out of this as much as I can. Not going to get out of it wholly, but attorney might be able to mitigate the damages. At best, I think.
Or appoint, oh, that's 2A. And then 2B, if you believe you're indigent, I will appoint counsel.
Could you explain indigent, please?
You don't have any money.
I'm sorry.
You meet the guidelines, you're in custody, and so I can appoint alternate defense counsel to represent you in the contempt proceeding if you are indigent. The actual language is in a Supreme Court guidance which says Colorado, I'll just read it to you. Colorado Rules of Civil Procedure 107 and 407 provide for the appointment of counsel to an indigent person cited for contempt where a jail sentence is contemplated. I am contemplating a jail sentence, Mr. Forenza. If the court appoints private counsel to prosecute a contempt action, which is not applicable here, or to represent an indigent party for contempt charges, that is relevant here, the judicial department will pay for counsel as there is no statutory authority for the public defender or alternate defense counsel to represent clients for the sole purpose of contempt. But to qualify, you would have to be indigent, which means you would fit below the guidelines for public defender representation. If you wish, I can print those guidelines out for you.
I would take a court-appointed attorney if I don't have the funds to get my own, my own high-profile lawyer. I would take a court-appointed lawyer. I need somebody to help you here. You obviously can't. I mean, that looks like that to me. I mean, look where you're sitting.
Don't want to be represented.
I'm sorry, I couldn't hear.
I don't want to be represented.
Okay, and you understand that, and I will allow you to make the statement of mitigation right now, but you understand you do have a right to counsel.
The only way to look at it is I never got a fair trial walking into this.
No, you're going to get a fair trial. You just messed up. Now there are consequences. That's called life.
He failed to prove jurisdiction, sworn affidavit. The courts failed, personal, subject, territorial. I moved it to federal. I even had documents which I sent. It was ignored. Everything gets ignored. I'm just, you know what? I guess I'll just let you beat me up, throw me in jail, get it over with, because you can't keep me the rest of my life. And then, I'll deal with the consequences and things later. I mean, that's where I'm at.
Okay.
It's not right over a traffic citation where all I did is I came here in good faith to resolve the matter. And it was just, I could get nothing. There's no nature and cause of there. There's no sworn affidavit for me to even move forward on. And this court can't move forward on. That's all I asked for. And it was like retaliatory. I just got beat up.
Not the traffic citation. That was nothing. A traffic citation was nothing. It's when you walked out of that court and the judge ordered you not to. That is the problem. You see, because he has got something we call jurisdiction. He's got jurisdiction over you. And now you sit where you sit. And you're going to sit in a cell for a while, it looks like. I were a betting man, that's what I would bet. All you're doing.
That's all this is. It's a traffic citation. It's not a crime. Nobody was injured. If that's, if that's what you call justice and fair, I'm not here to sit here and pick at anybody, go after, and that's not what it's about. When I posted bond for whatever it was, I came here and I didn't run. I came here to settle the matter. And that's all I wanted to do. And I just wanted a fair trial. That's it. But you get in my shoes, and how does it feel when you're just getting beat up and the judge you feel is being biased in the case? I mean, what do we do?
What else, Mr. Forenza?
Nothing else.
Mr. McCall, I should have asked you this before I moved to me. Is there anything that people want to say on this?
Your Honor, the people spent a good amount of time preparing for this trial. We actually brought the officer from across the state, met with him on the weekend beforehand to prepare for the trial. Officer Carnes was kindly enough, like I said, to drive on his own accord and his own expense to be here. he said he would come back for a retrial. He would request to be flown back, just given the type of the weather that it would be probably when it would be done. The people are still open to a plea agreement in this case for the traffic citations. We understand Mr. Forenza's stance as a sovereign citizen of what law he feels applies, but Your Honor, we believe that, the traffic laws of Colorado apply in this case. We are more than willing to negotiate a plea agreement to this day. But at this point, Your Honor, that's where the people are, Your Honor. We didn't anticipate any jail in this case. We didn't anticipate anything but to paying the penalties for speeding 25 to 39 over on the Riverside Parkway back in 2023. And the failure license. Your Honor, the speeding ticket, I would even reduce it to 20 to 24 over to keep it in as a traffic infraction.
On the contempt.
On the contempt, Your Honor. Your Honor, it's been an interesting case for me. I've never had a case that have gone this long with kind of like, the lack of being able to move forward. I've never been personally federally attempted to be sued in any case based upon a fee schedule. I find it interesting that Mr. Forenza believes that contract law applies in this case, but only one way, his contract law. The issue here, Your Honor, on contempt, the people expended a lot of time on this case for a very minor case. I do not like putting someone in jail in this situation. I just don't know if Mr. Forenza will ever show up to a trial again.
Yeah, and I don't blame you for not being sure of that. I'm also not sure of that. This guy had the gall to step out of court when the judge told him not to. He just walked out because he believes that there is no jurisdiction over him in this court. That's what he believes, even though he's in cuffs. Due to jurisdiction, the judge's jurisdiction over him. Now, I may be totally wrong. He might be an angel. I just maybe misunderstood. I don't know. But doesn't look like there's going to be any breaks for this guy. Doesn't look like that to me. What do you think?
For this case, or any case. He's done, a day or so in jail.
I'm not, anything else you want to say?
No, Your Honor. The people are, that's all the people are going to say.
Mr. Friends, I meant to ask Mr. McCall to make that statement before your statement. I forgot. If you'd like to make a statement to address anything he said, I'm happy to hear more.
Yes, I mean, I'm just objecting. I did, like I said, I came in good faith to settle the matter. And I tried. So it's not like I'm going to skip town to that. That's not what it was. Because if I did that, I would skip town.
Yeah, I don't know. This is a contempt of court hearing, not a bar hearing. Consequences, man. Consequences. We all have it. Good and bad. Court life.
I didn't do that. I came here to put the court on notice, let them know it's in federal jurisdiction. That's what I did. And I stood my ground for that. I have rights, and it's not about my contract. That's not what it is. And him for saying it's contract, and that makes it a commercial matter. So I'm here to settle the matter. Set off and discharge. And as a secured party creditor, I have a right to do that. An attorney, in fact, representing the estate. So I would like to do that. Let's settle the matter. Let's just wash this.
I'll give you an opportunity to resolve the matter, but we're talking about the contempt right now. I view the contempt as your direct and unequivocal disregard of the court's order.
Yeah.
What would you like to say in mitigation of that?
Your Honor, it's not, like I said before, it has nothing to do with that. I wanted to settle the matter. And I feel like I'm running in circles, nowhere to turn, but who do I have to turn to? I'm trying to get this resolved, coming into court and hoping in good faith that you do the right thing. And it just didn't seem like it was going that way. I've never gotten any response to anything I've ever submitted. And that's what makes it hard. So how do you react to that?
Well, I don't know what you have submitted. Maybe it's just a bunch of nonsense. I have no idea. Maybe the judge can clarify. I have no idea.
I mean, what do you do? Me, my situation, I'm scared. Okay, well, I have, torture cuffs and sitting here over a traffic citation.
Not because of a traffic citation. Not because of a traffic citation. That's not what it is. That's for contempt. That's what it is. I think.
Missed my daughter's birthday yesterday.
Anything else, Mr.
No.
Renz? Okay. Court finds the underlying offense can be resolved. As Mr. McCall points out, these cases are frequently resolved on the first appearance for a fine and be done. I find that Mr. Forenza, I don't know about negotiations. That's not my area not my area. But I find he has not litigated this in good faith. I find that he absolutely and unequivocally disregarded a repeated order of the court to come to the table on the morning of his trial.
And that is bad. That's why you're in an orange jumpsuit and you're cuffed and you're not gonna be at your daughter's birthday party. But that's on you. That's not on the judge. That is on you. That's how life works.
The remedy Mr. Forenza had would be to have the people try to prove their case beyond a reasonable doubt. He absolutely positively refused the court's order, despite repeated statements. It follows up a long history of disrespect from Mr. Forenza towards the court, and more specifically, the entire judicial system. I find there to be no good faith by Mr. Forenza. I am not addressing the underlying case. I do note that there's a new speedy trial date in that case. That new speedy trial date is July 8th, 2026. I thought about rescheduling the trial today, but I'm not going to do that. I'll do that at Mr. Forenza's next appearance. As to the contempt itself, and this is only as to the contempt, I note the difficulty. My plan was coming in to give 30 days jail, given Mr. Forenza's statement of indicating of the difficulty this has caused him. I'll reduce that a little bit, but not much. This case, I hereby sentence Mr. For direct contempt. I sentence Mr. Forenza to 25 days in jail.
25 days in jail. 25 days in jail. Because you got up and walked out of court when the judge ordered you not to. Told you to get to the bench. Come, sit and chat with me. Nah, you have no jurisdiction over me. I'm going to go home. I'm going to buy myself a burger. 25 days, free breakfast. You get a wake-up call every morning. They do your washing for you. It's great. 3 meals a day. I think it's amazing. Put some structure in your life and make you realize that, the judge does have jurisdiction over you. That's just what it is, man. Doesn't matter what internet ideology nonsense you follow. Life is life. Realities would be realities. And this is one you have to face.
Furthermore, I set this matter for hearing on my next in custody docket I'll put him, though it's going to be a busy day, it doesn't make a lot of difference. Today's the 8th. Yeah, I want to set him in the next round. I'll set him on the Friday, January 23rd, 1 o'clock in the afternoon.
Your Honor,
We'll
I
set
have
trial at that time.
obligations and things I have to take care of. Can I post bail? I will be here.
Yeah, I don't believe that. And I don't think the judge is going to believe it either. I think you're gonna be in jail for 25 days. I think that's what's gonna happen.
So noted. I've sentenced you on the contempt, Mr. Forenza. The next issue will be when I see you next time on the 23rd, all right, is whether I should release you in custody on bond after the contempt sentence is over.
All right, let's stop this video right here. There's about a minute or so left of nonsense. Yeah, I don't get how many sovereign citizens win their court cases. How much has their ideology strengthened in the last few years? I know there are weak judges, there are weak DAs. I know that, and they let these guys go. But judges like this uphold the law, you're going to go to jail. Doesn't matter what your ideology is. There are laws which you have to abide by. That's as simple as it is. Anyway, thank you so much for watching with me. I do appreciate that. If you have not yet subscribed, please go ahead and do so. Give us a like, share, and a comment. These things are all good for the algorithm. Great stuff. I'll see you in the next one.